In the winter of 1889, a devastating flu strain spread across the globe, leaving an estimated 1 million people dead. Medical science at the time did not understand viruses. Doctors were powerless to stop the spread, and a terrified public was willing to try anything to avoid infection. As we see in these dense Victorian newspaper clippings, opportunistic businessmen quickly filled the void. They flooded the market with unregulated potions, pills, and bizarre devices, promising absolute immunity from the disease. One of the most popular items was the Carbolic Smoke Ball. It was a hollow rubber sphere filled with powdered carbolic acid. The instructions told you to place the tube in your nostril and squeeze, blasting the harsh chemical dust directly into your nasal cavity to supposedly neutralize the flu. There were no consumer protection agencies to step in. It was a highly profitable market built entirely on exploiting public fear with untested, often dangerous medical claims. To cut through the noise of competing miracle cures, the Carbolic Smoke Ball Company adopted a strategy of absolute, undeniable certainty. Look at this advertisement. They prominently offered a massive £100 reward to anyone who contracted influenza after using the smoke ball. The text specifically points out that £1,000 is deposited with the Alliance Bank to prove their sincerity. The company executives assumed this was standard advertising puffery. They figured no single person could ever prove they followed the directions perfectly, making the payout impossible to collect. By printing a specific financial guarantee tied to a specific bank deposit, the company had inadvertently drawn up a legally binding trap for themselves. Louisa Carlill, a pragmatic citizen living in London, read the newspaper and took the company at its word. She purchased the device and followed the printed directions to the letter. From November to January, she faithfully inhaled the dust 3 times a day. On January 17, 1892, she contracted the flu. The product was entirely useless. Her husband, a solicitor, wrote 2 letters to the company demanding the £100 promised. The company ignored them. On the 3rd attempt, the company finally replied with an anonymous letter. They refused to pay, insisting that, to prevent fraud, Mrs. Carlill would need to travel to their office every single day and use the smoke ball under the supervision of their secretary. A defrauded citizen was up against a wealthy, faceless corporation that had zero intention of honoring its own public promises. Instead of walking away, Mrs. Carlill filed a lawsuit for breach of contract. The company hired a formidable legal team, led by elite barristers, including future Prime Minister H.H. Asquith. They viewed the lawsuit as a joke. In court, their primary defense was that the advertisement was a mere puff. They argued that any reasonable person knows marketing language is inherently exaggerated. Second, they invoked traditional contract law, which required a private meeting of the minds. You cannot negotiate a binding agreement with the entire world simultaneously. Finally, they pointed out a technicality. Even if the ad was an offer, Mrs. Carlill never sent them a letter formally accepting it before she started using the product. The company weaponized old, strict rules of face-to-face commerce to shield themselves from a promise they broadcast to thousands of anonymous readers. The case escalated to the Court of Appeal. The 3 presiding judges looked past the rigid traditions and focused on the practical reality of modern commerce. The judges pointed directly at the company's claim of the £1,000 bank deposit. You do not place real money in a vault to back up a joke. That detail proved a serious intent to pay. To address the issue of negotiating with the public, the court firmly defined the concept of the unilateral contract. A unilateral contract is a one-sided agreement where one party promises a payout in exchange for a specific performance, rather than a reciprocal promise. Under this rule, a business can broadcast an offer to the entire world. The moment an individual steps forward and fulfills the specific conditions of that offer, they are legally bound. The court ruled that inhaling the dust 3 times a day was the acceptance. The act of completing the task eliminated the need for a formal notification letter. The ruling stripped away the defense of hidden intentions. If a business acts as though they are making a real promise in their advertising, the law will hold them to it. The judges dismissed the appeal unanimously. The Carbolic Smoke Ball Company was forced to hand over the £100. The company went bankrupt a few years later. Louisa Carlill lived to the age of 96, before eventually succumbing to the flu in 1942. This verdict cemented the objective theory of contract in English law. The objective theory of contract is a legal principle stating that an agreement is judged by the outward actions and words of the parties, rather than their secret or internal intentions. Overnight, the advertising industry had to adapt. Businesses realized they could be sued for specific claims, leading to the use of careful disclaimers and the eventual creation of strict regulatory standards. Whether you see a money-back guarantee, participate in a bug bounty program, or claim a public reward, the legal mechanics function exactly the way the court outlined in 1893. The foundation of modern corporate accountability exists because one citizen inhaled a useless powder, got sick, and forced a company to pay the price for its own words.